Hello and welcome to Rights and Recourse, a program that informs and educates you, the viewer, about your legal rights and legal recourse. I'm your host, Dumila Matez. Is our legal system adequate to ensure access to justice to South Africa's diverse society? Well, many argue that it is high time that the current legal system, which is rooted in English and Roman Dutch laws, is transformed to infuse indigenous value systems, all with a view of enhancing access to justice to all. But before we delve into the discussion, let us first take a look at this background insert.
It may be a scene from a local story, but it captures how justice was administered by local communities. It all changed after the arrival of Jan van Riebeeck on the Cape Shores in 1652. Today, 352 years down the line, the country's legal system still reflects largely colonial and apartheid values. Like many other African states, democratic South Africa is still trying to find best ways to reform its legal system to reflect its diverse society. A journey that started with the adoption of the new constitution in 1996. Even though the constitution recognized customary law, the country's legal system remains dominantly Western. And that is why many insist that the marginal integration of indigenous laws into the current justice system is not enough. Making a case for traditional forms of dispute resolution, Advocate Dumisa Ntsebeza echoed the views of many in arguing for a return to indigenous value systems, all to further improve access to justice.
Into ibichothelwa kuthi hayi mababizwe bonke sobamamela chothelwe ngabantu bonke. Into enayo ngoku kungene umkhwa esiwufumane kwizwe lasemzini, umkhwa othi mazilime ziyetyeni. Yabona ke ilahleke apho.
On the other hand, there are still those who remain skeptical, arguing against the infusion of the indigenous legal system. They believe the current constitution adequately covers the interests of all citizens. Accusations of women disempowerment in its incompatibility with modern standards are some of the views that have been advanced to maintain the status quo. But merits on both sides of this argument will remain a debate for many years to come.
Well, welcome back. Joining us today's discussion are Dr. Matola Mutsega, Chairman of the Parliamentary Portfolio Committee on Justice. And from our Pretoria studios, we welcome Advocate Jacob Boetie-Skhosana. He's the Deputy Director General in the Department of Justice in charge of policy development. Gentlemen, good afternoon and welcome to Rights and Recourse.
Afternoon to Advocate Skhosana.
Dr. Mutsega, let me start with you. In the insert there, they talk about the marginal integration of customary law into our jurisprudence. How did we come to this? Many people are saying customary law is seen as a stepchild to our jurisprudence.
We came to this because we were a colonized people. In any colonial situation, the colonial power imposes its legal system, informed by its own values, and also the need to secure social and political power. And if you have been colonized for 350 years, you can imagine that you will come out with a legal system that has nothing to do with your values, that has nothing to do with your aspirations, but everything about those who want control over you. And that's the situation we have.
Advocate Skhosana in Pretoria, isn't the fact that the application of law is based on fairness and justice only? Advocate Skhosana, I don't know whether you can hear me. Isn't that the application of law is based on fairness and justice?
Yes, that's correct. It's based on fairness and justice, but from the perspective of the people, how the community views what it thinks is fair and is just.
So you probably want to come in there,
Yes,
Dr.
yes.
Motshekga.
You see, what is fair to the colonizer is not fair to the colonized. Now, we have standards of fairness and justice determined by the master for the servant. Now, so the playing field is not equal. So you can't even talk about fairness and justice. That's why Advocate Nsebenza is right to say we must go back and see what are the positive elements in our own indigenous law, because you see, English common law as well as Roman Dutch law are based on the customs and values of those two foreign nations, and therefore they cannot necessarily reflect what is fair and just in an African context. Now, we decolonize the country. Now we also need to decolonize the law, hence the call to say, let's change and infuse indigenous values, because you see, for the majority of the people of this country who have no experience of Roman society, English society, they cannot see and access justice under the current circumstances.
Advocate Skosana, we go back to you again. The question for me is, in the development of our constitution, we had an opportunity to create a confluence between the indigenous and Roman Dutch law and the English law. How did we allow this to happen if we believe that it is incompatible with indigenous law?
The Constitution provided a framework for the development of the new identity of the legal system for South Africa. When the Constitution was adopted, there was that understanding that over time, the Constitution provides an opportunity to develop a legal system which talks to the value system of the people of this country, and which every person could basically be associated with or embrace the system. Obviously, what has happened, as Dr. Motshekga said, we have taken some time to come to that position. We have allowed the Roman Dutch law and the common law to continue for quite some time. We had the process of infusing the indigenous law system has been rather too slow, but has also excluded the people outside the system. That is, the people who are from that system. So the process of going back to infuse the system must involve the people of South Africa.
Dr. Motshekga, quickly, in response to what Advocate Skosana is saying, Section 12, Chapter 12 of the Constitution, with reference to traditional authority, says, and I quote, "The courts, in accordance with the traditional authority, must apply customary law when the law is applicable, subject to the Constitution and any legislation specifically dealing with customary law."
You see, Advocate Skosana is correct. That section in itself is discriminatory, because nowhere does the Constitution say that English common law and Roman Dutch law should be applied subject to the Constitution. We just assume because what is Western is superior. Why no such a formulation? But we can excuse the framers of the Constitution because they were under pressure. They wanted to bring peace to the country. But as Advocate Skosana correctly says, the Constitution created a framework and gave us space to address these issues. So that process has been slow, and I hope that Advocate Skosana and ourselves will make sure that we speed up the process, because failure to do so, it would be a grave injustice to the majority of the people of this country.
What aspects of our jurisprudence should be taken up in the drawing up of this new part that deals with customary law?
You see, for instance, we talk about land policy, for instance. There are huge problems there. Our people owned land communally, and the king or chief was held the land in trust for the people. Now we are saying we must return the land to the people. What do? We say any group of individuals can come together, point out graves of their ancestors, and those three can go and register a community property association or register a trust, get the land, whilst in that area, the king or the chief are still alive, who own the land. And now also it depends who were first to go and apply for the restitution. Now you may find that out of 1 million people, only 600 then are recognized as the owner of the land to the exclusion of the others. So you can see the jurisprudence of the West, which is based on individualism, then works against the collective or communal jurisprudence of Africa. So in other words, this is not just about laws, it's also about the meaning of justice, the jurisprudence, which is not being addressed. Secondly, we say that we come from a tradition where people say you can marry more than one wife. Our laws now accept that, but we still keep the Western position which says no, one man, one wife. Now, if I'm a chief, I have 10 wives, I divorce one or one divorces me, the court will say divide the estate. Which estate? Because as the head of the family with 10 wives, I am actually the custodian of a family estate. It doesn't belong to me, it doesn't belong to any one of the wives, and it is not organized in terms of percentages. So you have a law that does not reflect reality. And that's where then law gets discredited and law gets delegitimized. At the end, we have a situation where people don't respect the law because it doesn't make sense.
Dr. Mseka and Advocate Skosana will continue our discussion here. If you would like to join us in today's discussion, please call us on 011 714 5497 or 5498, or tweet us at Rights Recourse, or email us and tell us what stories can we do at rightsandrecourse@sabc.co.za. We'll be back after the break.
The shortage of nurses places those nurses who are working under such pressure.
To have one registered nurse looking after a ward full of patients, of over 40 patients, is unreasonable.
But Africa has made tremendous progress. In the year 2012, there were only 50,000 children, 50,000 children too many, but only 50,000 children that died of measles in the whole of Africa, compared to 330,000 in the year 2000.
For all your health issues, join Dr. Sello every Saturday, 9 to 10 a.m. CAT.
Zoom into Africa. This is Nigeria. The president is Mr. Goodluck Jonathan. Nigeria attained independence in 1960. The population is more than 166 million people. One of the major languages spoken is English. Monetary unit is Nigerian Naira.
Welcome back, and as we continue with our discussion comparing traditional indigenous law to the Roman English Dutch law as we know it. I read some tweets quickly. There are some tweets that came around. Integral part of our law and be freely practiced properly, and that's what many people are saying, and that's Tsietsi Pelesi. Somebody calls himself, I love the ANC, says customary law should be observed under traditional affairs bill. That is coming up, as Mrs. Kosana told us earlier. When it comes to witchcraft killings, the only solution is to find out which man is more reasonable. And let's go to the lines quickly. Let's speak to Mafayana. Mafayana, good afternoon and welcome to Rights and Recourse.
Good afternoon, sir. How are you?
Fine, thanks. How are you?
I'm okay, sir. Good afternoon to your guests as well.
Dr. Mutsega and Advocate Skosana.
Good afternoon.
Yes.
Good afternoon. Yes.
Sir, there are two things in Toulouse, John. Firstly, since Dr. Mutsega is the chairperson of the Justice Portfolio Committee in Parliament, the laws that are governing the activities of Parliament, are they colonial laws or are they influenced by colonial laws or whatever? And then secondly, if they are influenced by colonial laws, when is Justice or Mr. Mutsega going to change those laws? Because it seems as if the laws that are regulating the activities there in Parliament were created by the colonial people. Now, when are we going to have our own laws that are informed by our customary legislation? Thank you.
Well, thank you very much, Bafanyana. Bafanyana is asking a question that everybody has been dealing with over the last couple of months, and that is the rules that are governed by the Rules and Privileges Committee. He says those rules are colonial rules. Are they colonial rules, and when are we going to infuse within Parliament, in the way Parliament is run, our own traditional laws?
No, I think that I would have looked at the matter broadly to say that you see, we had to move from the old system to the new. But you can't move by creating a vacuum. You have to carry over certain previous laws and then create a constitution, which, as Advocate Skosana correctly said, creates a framework for a transformation of the legal system. So the transformation, the framework is there. Now it's for us to transform the laws, but that as well cannot be done overnight. So that's why I think Advocate Skosana is right to say we need to start that process, but that process cannot be started by us as Parliament alone or the Department of Justice alone. We need to involve the people, because at the heart of the matter is what is the people's concept of justice, because that people's concept of justice is what must form the bedrock of the new jurisprudence.
Advocate Skosana, I wanted to keep this for now, but let us talk about the elephant in the room. We do have traditional courts in South Africa, despite the fact that the traditional courts bill that was being promulgated by Parliament was withdrawn due to the opposition, mainly by women, who pointed out that these courts would be patriarchal in nature. When are we seeing this bill back in Parliament? Did you hear me?
I did not pick up the last point.
The last point was the traditional courts bill, which was being promulgated by Parliament, was withdrawn because there was a great deal of opposition, especially from the women folk, who said the court would be patriarchal in nature. Dr. Mutsega was, oh, did you get that now? I think he's got an echo coming. He's got an echo. That's why you wait so long time. I don't know whether you want to tackle that whilst he's collecting his thoughts.
No, I can. You see, we first have to identify the opponents of the bill. What is their constituency? Where are they based? And from a thug, you will find that they are located in the big cities. They are not necessarily representing the women in the rural areas. So when we say involve the people, we mean especially the people that are affected. So I'm still not convinced that the people who are opposed to the bill are representative, to the people that are affected by the bill. And that's why we are in agreement with the Minister of Justice that we need to bring this bill back to to Parliament and consult with the people, especially those that are affected. Because to generalize the fear against patriarchy, you have Mujahid, the Rain Queen. Women have been in power for 1800 years, and women were presiding over their community just structures. Now, so you have a model where you can...
There's also the case of the Queen of the Khoisan, who was a woman, apparently.
Exactly. And if you ask the opponents whether they did look at the Ho case, the Mujaji case, you find that they don't even know where these places are located. So my view, with due respect, would say that the consultations were not exhaustive and inclusive.
Advocate Skosana, quickly, probably including with your thoughts on an earlier question that I asked. I seem to remember, I think you were driving this process from the department's point of view, that the House of National, the National House of Traditional Leaders did have hearings in all the provinces, and all the provinces, bar two, the Northern Cape and the Free State, did not want the Traditional Courts Bill. Am I wrong or am I right?
In fact, prior to that, the South African Law Reform Commission undertook extensive consultation countrywide. But let me explain what the challenge is. I think South Africans must understand that as we sit and talk here, the traditional courts are existing and continue to function. The challenge is that so long we delay the new bill or new legislation, they continue to function in terms of the Black Administration Act of 1927, which is unfortunate. Now, those who oppose the bill do not understand do not understand that the attempts government is trying to do is to regularize the traditional courts so that they must function in line with the Constitution. The more we delay the bill, the more they continue to function in terms of old order. And that old order creates a lot of challenges in terms of patriarchy, inequality, and also exclusion of certain groups from the participation in the system.
In other words, what you are saying,
women, yes.
Thank you. What Advocate Skosana is saying, if I understand him correctly, he said if the traditional courts are going to continue to function as they are functioning now, outside the jurisprudence, you can't deal with issues of patriarchy because they are functioning outside the jurisprudence.
You see, I agree with him. What the point I'm addressing is that the groupings which are opposing have not spoken to the constituencies affected. Now, he's saying there was sufficient consultation with the affected people, but those that are not affected and have not spoken to the affected people are the ones that oppose the bill. And it is true that these courts are functioning and every day, and injustice is being meted out every day, and you cannot postpone access to justice by our people because of unrepresentative and groupings.
Apparently, Advocate Skosana, if you can come into this, it is not really true that colonialists did not want the traditional system of governance or the traditional court system to be implemented. I seem to remember in my research, in 1843, indigenous law was recognized. Theophilus Shepstone, Usomtseu, recognized indigenous law and resulted in the codification of the Zulu law. But this was disregarded by the people.
No, the problem is that you found that Theophilus and others, they go and use white anthropologists who can distinguish between custom and law. And these people produce some confused thing, and it becomes codified. And that's why the people reject it, because it's not reflecting what... I mean, if you don't speak Zulu, how do you go and codify Zulu law?
Advocate Skosana, it means, if we're going to introduce the Traditional Courts Bill, then it means the Black Administration Act of 1927 must be repealed, isn't it?
Yes, because that act remains intact. As Dr. Msakhav said, you cannot have a vacuum. Now, because you cannot have a vacuum, Parliament have extended its operation until such time that there's new legislation enacted in terms of constitution that will address all the challenges and the weakness of the system. Now, as long as that process gets delayed, the old act remains operational. Let me just also explain one thing in terms of constitution. The constitution enjoins not only the courts, but also enjoins traditional institutions, other structures, other fora to transform and develop our customary law. Now, the courts may not be well positioned to do that because, as we have said earlier on, we may have issues of training. People may have been studied law in Roman Dutch law. We might have studied law, etc. The custodian of the traditional value system are left outside the system. Now, by transforming and democratizing the traditional justice institution, we are also empowering them to start the process of transforming the customary law so that all those issues of inequality in terms of marriages, in terms of succession, in terms of property get addressed.
Do you want to come in there, Doctor?
I must say that, this matter is very serious because by not taking advantage of this traditional courts and other dispute resolution mechanism, then you have the backlogs in the courts and then resulting in other backlogs in the correctional centers, and then there's nowhere, you don't have a situation where you rehabilitate the offenders. And all these things put together, they then erode the image of the judiciary. And then you will have a situation where the people begin to blame the judges, to blame the magistrates, and lose confidence in the judicial system. Whereas it is not the judiciary that is failing us, it is the slowness in transforming this other structure. So I think that is quite an urgent matter that must be addressed if we need to preserve this judiciary of ours that has...
Quickly, Dr. Mutsecha, the advocate Skosana referred to people have been trained in Roman Dutch law. Are we saying there should be a change in the curriculum of training our lawyers and advocates?
Like yesterday, because if you train people in Roman Dutch law and English law, they know nothing about indigenous African law. They will go and apply what they know. And the other thing is English and Afrikaans and Latin were compulsory for people who want to practice law, but indigenous languages are not.
We will continue this discussion. We'll pick up just where we are. If you'd like to join us on today's discussion, please, you can call us on 011 714 5497 or 5498 or tweet us at Recourse. We'll be back after the break.
More than 230 people in Pakistan and northern India have been killed in torrential monsoon rains, which triggered flooding, landslides and house collapses.
Future is doomed already because I didn't write exam June. I didn't apply. So I don't know from now where I am going to do because I'm sitting at home doing nothing.
We're running against time and we're losing lots of time, losing a momentum. It has reached a stage of extreme urgency.
Triumphant South African national cricket team arrived back from Harare confident of the future. The Proteas trounced Australia by 6 wickets to claim the triangular series title in Saturday's final.
Peter Ndoro, he's out and about today. He's at Tsitsikamma National Park to officially launch Sand Parks Week, as well as celebrate the national park's 50th birthday.
I've got to tell you, it's picturesque beyond words.
The people are really friendly and nice here. It's like the different kind of nature. You have mountains and you have the ocean, and it's all in one place.
That's Morning Live, daily at 6 a.m. on SABC News.
Welcome back. Let's have a look at what the Twitter community is saying around this very issue. Pilani there says, I support the Constitution when it allows the application of customary law provided it is not contrary to the Constitution. I'll get Dr. Mutsega to respond to that. Togadi says, should customary law not be seen as common law? Or it's a tweet by, is retweeted what Rights and Recourse has been saying, whether should customary law not be seen as common law as in an integral part of our law. John Jackson says, reject all that European Western and lead Africa back to its roots. Then you will be happy. Dr. Mutsega, first let's start with the first one. That said, customary law can be practiced, but it should be practiced within the realms of the Constitution.
That is correct. But in the past they said it must be practiced provided it is not against Roman or Dutch law. We call that the doctrine of repugnance.
The doctrine of repugnance.
But now we correctly say that it must be consistent with the Constitution. But we don't say the same thing of English common law and Roman Dutch law, because those two are also systems of customary law, and they should not be more equal than African customary law. And now on the question of the common, African
customary law being a common law.
It is. The only thing it is not is because somebody else other than ourselves decided, but their decision was wrong, and we must correct it now.
Advocate Skosana, one of the other things that were spoken about against the Transitional Courts Bill was the fact that the bill was not very firm on aspects of our daily living, especially in rural South Africa. Issues, the bill did not deal with issues like ukutwala and the killing of those who were smoked out as witches. What I'm actually trying to say is, did you look at the things that were raised and corrected them, or are you in the process of doing that?
Let me explain the purpose of the bill. The purpose of the Transitional Courts Bill is not to rewrite customary law. I've said that the development of customary law is in the hands of the courts, or is in the hands of the institutions of traditional leadership, or any fora or tribunal so empowered by the Constitution. The Transitional Courts Bill set up to establish a mechanism through which the institution of the traditional leadership can take lead in transforming the traditional justice system. There are practices that are part of our custom which still continue and can never be stopped. There are practices of ukulobola, ukutwala, ukungena. There's ways in terms of which people mourn their death in the customary way, etc. You cannot take all those aspects out. And those things every day become part of a dispute in a court. And the current courts, the modern courts, are not empowered to deal with issues of ukulobola or damage, where a man have impregnated a woman. Also, all those aspects are value systems that can be dealt with appropriately by the system itself. Now, in terms of public sector, you will notice that our current public justice system does not take into account restorative justice. And we can take the recent example of the case of Pistorius. Now, all that the court's doing is calling witnesses, hearing how River Steenkamp was murdered, etc. But there is no opportunity to bring the family of the deceased or even the community, because in customary law, any offense is an infringement of communal values. The community and the people affected by the disturbance of the order have the opportunity to make their own reflection and all their feelings, so that the court can take a balanced view of how to deal with those disturbances of the legal system. Now, in an Eurocentric system, the focus is on the accused and not on the community. It depends on how the courts, how the judge, how the magistrates interpret the value system of the community without allowing them to participate in the process. Hence, we say that the Transitional Courts Bill does not rewrite customary law. It provides a mechanism through which the institution of traditional leadership, but also the interplay between the traditional justice system and the modern justice system can basically produce an infused legal system that responds to true access to justice, in terms of which it can respond to the aspiration of the people.
Something Advocate Skosana raised there, restorative justice. There's one thing I picked up in my research, that customary law is very strong on restorative justice, which is a system that is embedded in our culture.
Because you see, the purpose of law should be to ensure that the social order is not disturbed. Now, if you are going to kill 50 of my cattle, you get arrested, they give you 6 months imprisonment, I still don't have my cattle. How am I going to be satisfied with the outcome of that court? So restorative justice should be key in our legal system. But secondly, you know, if you charge a person, you say he committed ukungena. Ukungena does not belong to the traditional court bill. Ukutwala does not belong. Those things are not law. Those are methods of effecting certain agreements. For instance, if my brother passes on, he has 10 kids, and now the estate belongs to the family. We can't take the estate and give to his wife to go and marry some other guy to take that estate. We say, no, I will look after my brother's family, but provided it's not done against the will of that woman. So it's something that is mediated between the families, it's agreed. But unfortunately, these days we have opportunists who abuse that. And because this practice is abused, we can't say it must be incorporated into the traditional court bill. It doesn't belong there. Ukutwala. Ukutwala is a way of effecting.
I think the objection to ukutwala not being catered for, a case of ukutwala and a rape case for that matter might be withdrawn from a traditional court because ukutwala might be seen as a custom. This is my custom. I normally do this thing. This is accepted in my custom.
Contrary to what is being said elsewhere, ukutwala is not something offensive if it's done properly. Because what happens is that two people fall in love and the families agree, and it is agreed that on a particular night, some people will go and fetch the woman into the new family. But what is done now is done forcefully, and also even against people who have not consented, where there's no agreement. But for that, you don't need a traditional court bill. It's a violation of the law. Those people should be simply charged with criminal offenses and be dealt with.
Advocate Skosana, there's another thing that I wanted to put to you. I think the Department of Justice has been dealing with that, the issue of mediation, which is another strong pillar of customary law. Mediation in terms of if there is a rivalry between two groups in a village, the king calls them together and try and mediate between the two. Isn't that something that belongs to what we're talking about?
You are correct, Dumile. Mediation. You are correct, Dumile. Mediation has its origin from the traditional justice system, and it finds its basis on the value of Ubuntu, and it simply means that where there's been an infringement, there must be a humane way of dealing with the matter in a way that can bring two parties to a amicable solution, not an adversarial system. Currently, our legal system is steeped in the old Eurocentric way of dealing with things. Adversarial, when there are disputes, you bring your lawyer, they bring their lawyers, you go to court to fight it out. The judge stays, doesn't listen and gives judgment at the end of the day. Whoever wins takes everything home. Whoever loses everything. Mediation is differently. First, it allows people to come and talk about their own dispute and see how they can resolve them. Now, one instance where mediation can be used successfully is the whole issue of maintenance for children. Every day at the court, the dispute is not whether it's when the matter is, this is not my child, it's a dispute of paternity, that matter can go to court. But in most instances, the disputes about the amount to be paid, the negotiations between the parents, etc., to the benefit of the children. Why should we allow that process to be judicialized when it can be resolved by mediation so that the parties can go out there freely and all those problems of access or custody will be resolved because they all understand that this remains our child and we've got a joint responsibility of making sure that the child grow up. But once you bring an adversarial system, you bring people against each other and you allow the judge or the magistrate to be the referee at the end of the game and rule without their own involvement and sharing their own view. So Minister Masuta has published the new mediation rules, which are operational from the 1st of December this year in certain courts. And with the view with those mediation rules is to start institutionalize this new innovation to make sure that most of the cases in courts in civil cases are resolved in a manner that will promote an amicable resolution of dispute.
Dr. Mutsaga, you wanted to
Yes, I wanted to say that, you see, the point that Andrews Kosana raises of adversarial system then comes to the issue of the gap between the rich and the poor. Now, in such a system, those who have money or more money already have an advantage before you start the race. Now, in the traditional sense, you have an inquisitorial approach where I am both your lawyer and your prosecutor, because I look for the good points on your side and acknowledge them, and I look for the weaknesses, and we all do that. At the end, we say, what is the balance of fairness here? And then you will find that there's consensus, even a consensus that even includes the people that have been offended by you to say, no, we think that here we should not be harsh with this person. And that's where the whole philosophy of Ubuntu comes in. Treat these people
I'd
fairly.
rather to keep that thought on Ubuntu because I want you to expand on the Ubuntu part when we come back. If you'd like to join us on today's discussion, please call us on 011 714 5497 or 5498 or tweet us at Recourse. If you want to send us anything you want us to deal with, you can email to rightsandrecourse@sabc.co.za. We'll be back after the break.
Ja, ik heb een paar bezig. Kom.
Who are we, you ask?
This is who we are.
We are technologically driven.
We are unashamedly Afrocentric.
We advise you not only on legal matters,
but on health issues as well.
We bring imagination to life.
We celebrate arts and culture and lifestyle.
We tackle life challenges head on.
We dig deep. We probe. We question.
We invite you to take a view from our house.
As we tell it without fear, separating fiction from factual.
We are the SABC News Channel.
All news, all global, all the time.
Welcome back. When we left the last time before we went to the break, Dr. Mutsaga was still talking to us about the concept of Ubuntu and how that concept, it can be one of the cornerstones of customary law.
Because Ubuntu, which you find in all languages, in the indigenous languages, Ubuntu, Butu, Bunu, it's about the humanity of everybody. And that's why our icon Nelson Mandela said, I am because you are, I am through others, which means, to start with, I cannot and should not do to you what I don't want you to do to me. Already that is a basis for equal treatment of others, because no one wants to be injured, no one wants to be hurt, and therefore no one must hurt or injure others. And then they will come and say, you know, if you eat next to someone who's not eating and is hungry, it's like you are scolding that person. In other words, you have to share with others what you have. And now they will come and say, it takes a village to raise a child. Now, if you come running and blaming other people's children, they will say, what have you done to make that these children become the type of children that society wants? Now, it means, therefore, that there are certain rules that crystallize out of this philosophy of Ubuntu, which are shared by the community as a whole, and they contribute to building socially cohesive communities and a good foundation for the nation.
Advocate Skosana, quickly, in the time that we have left, let's go to how do we then harmonize and integrate customary law with Roman Dutch law and English common law?
Society needs to take an active approach to the process. And as we have said, time is no longer on our side. There have to be structures on the ground that start to get involved actively in making sure that they participate in the development of the law. That will assist Parliament to move forward with the speed. But also from the court perspective, there's a lot of jurisprudence, court decisions that come out, emanate on matters that affect the people, etc. And I think it's high time that people engage with the decision of the courts, express their views, so that at the end of the day, the courts can be guided in terms of what jurisprudence will best address the needs and challenges of society.
I like your use of the words people, because Dr. Butsega, I've always argued that probably we should change the way we address this issue. When we talk about so-and-so versus the state, we should probably say so-and-so versus the people.
Exactly. Exactly. Because you see, the state actually is seen as some entity created by the law. But at the heart of the state is the people.
It's the people.
Yeah. Don't offend the people.
The question I actually wanted to ask, there is a view that South Africa would be poorer without the sound discipline, effectiveness, and historical experience of Roman Dutch law, and will also be poorer without the spiritualizing, humanistic, and bonding values of customary law. How can these legal systems be reconciled in your view?
You know, there's not even a need to reconcile anything. The people that live today are a reality of today. They have their own spirituality, they have their own aspirations, and whatever law we make, we're not going to apply to the dead Romans, but to these people that live today. So let's have regard to our current realities and the spirituality of the people. And luckily, the philosophy of Ubuntu that we have is a philosophy that is universal. It transcends race, class, color, and creed. So why can't we simply, as South Africans, say, we have this universal philosophy, let's infuse it into our public service, into our laws. We'll find that, as Mandela did, we have a harmonious society. We don't have to be going back to Rome, and that Rome has even changed. It's no longer what it was.
Advocate Skosana, the other question I wanted to ask from you, would this, what we are trying to do, bring in customary law and we have two other existing laws that we're using in our jurisprudence, not make the dispensing of justice cumbersome?
In fact, what will happen, the infusion of traditional law into a system will reduce the legalism and formalism and the rigidity of the law, because we all know that the traditional justice system is known for its flexibility, is known for its speed, and it allows language imperatives to be talked. Currently, those measures are lost in the formal justice system. Now, what will happen in terms of the new legal system for the country? It means that the Constitution will allow both the Roman Dutch law and the English law and the traditional law to build on what is good from all those dispensations, so that we can develop a new, uniquely South African legal system that addresses and talks to our own experiences and own aspirations as a community.
Dr.
And
Mutshekga,
those are the... Yes.
Quickly, Dr. Mutshekga, you want to make your point when we come back from break. We've got to go to a break quickly. You want to take part in this discussion, you can email us, or you can actually send us a tweet on Rise Recourse, or email us at riserecourse@sabc.co.za. We'll be back after the break.
Icons is a unique visual journey of some of South Africa's greatest citizens.
When I wake up in the morning, I've got a challenge.
You succeeded in getting me to do something which is absolutely against my nature.
If I do something, I do something properly.
In celebration to 20 years of democracy, the newly released book 21 Icons offers exclusive access to a remarkable spread of South African legends.
It tells their personal stories and unique portraits that reflect our country and, above all, its people.
That's Kaleidoscope, Sundays, 5:30 p.m. on SABC News.
In Parliament, Higher Education and Training Minister Bladen Nzimande has conceded that the bursary scheme is not enough to meet the growing demand from students.
Funding for universities is not enough. We'll be open about that. We will continue to ask for more from government as a department.
We've always said that the NSFAS budget must be 16 billion rand and that no qualifying student must be prevented from studying just because they cannot afford to do so.
There's been concern about citrus exports to Europe and investment contracts.
There are more opportunities for us to sell sugar, wine, ethanol, some fruit products than we had before, and that could create jobs.
That's business news, weekdays at 6 p.m. on SABC News.
Welcome back. Dr. Mutshekga, we spoke at some stage during the break about the need for a curriculum change within the way we train our advocates and people we expect to be judges and magistrates.
Quite correctly. You know, the transformation that Advocate Skhosana is calling for can actually speed it up by the curriculum change. Firstly, you need future lawyers to have at least one African language as a compulsory language. You need indigenous African law to be compulsory. You need our lawyers to understand the traditional government structures, because when decisions are made in the traditional courts or other community courts, the appeal lies to the modern courts. Now, if the people in the modern courts don't understand the system where these appeals come from, how are they going to be able to take the correct decisions? That would limit access to justice. So we need a comprehensive transformation of the legal system And that can be achieved through the curriculum change. So this so-called autonomy of universities should be revisited, because universities do what they like, then they produce people that are not competent to deliver justice to our people.
When you talk about people who are not competent, there was this big debate about the LLB degree that's still going on at universities. Advocate Skosana, the question I want to know, taking it from what Dr. Mutseha was saying here, what is going to happen with the bill now if it goes back to Parliament?
The process of redrafting the bill is underway currently, and I think there's still going to be further consultation. The minister anticipates to go back to cabinet with a new revised bill. I would like to say that all the years that we have engaged on this bill in Parliament, there have been quite a lot of useful lessons that have been kind of learned and which have now been infused in the new bill or so before it's taken forward. So we are looking at a process of 6 months to a year by which the minister may approach cabinet with a new revised bill so that committees can be consulted, and we hope and trust that bill will then be moved forward with speed. I just
quickly,
want to comment
Dr. Skosana, Advocate Skosana, we have run out of time. I just want Dr. Mutseha to make a comment on something I want to raise with him, and that is one of the problems with the bill was that the decision of the court, of the Transitional Court, cannot be taken on review.
You know, it would be important that provision is made for that. At the moment, there's no such provision. But I think people should be allowed to approach higher courts so that when they lose, they will be satisfied losers, and that will ensure stability.
Gentlemen, thank you very much for your input on this program today. This has been Rights and Recourse. The program is repeated at 10 tonight and 5 on Monday morning. From all of us in the studio, thank you very much to our guests, and good afternoon.